Hi, I'm attorney Valerie Hicks Powe of the award-winning Valerie Hicks Powe Show, and welcome to my video blog. This week's blog is dedicated to the issue of employment discrimination. As a civil rights attorney focusing in the area of employment discrimination, I have a lot of inquiries about that subject matter, as you can imagine. A lot of them are in the form of email, where people will email me questions about whether or not the facts that they present, whether those facts amount to a case of employment discrimination. And what I've decided to do is to take some of those. I may even mix them up a little bit. I'm going to change the names. The names will be changed. I won't identify the companies. We'll address the type of companies involved to the extent that's necessary to deal with the fact scenario as presented, and then I'm going to bring it to you. We'll discuss it here at the video blog and give you an idea about employment law using actual scenarios. And I hope that you'll find it helpful. If you would please, if you've had the occasion to watch the blog, particularly when we do the issue of employment law, I'd love for you to comment and let me know what you think about the topic. And you may even suggest a subject matter or a topic, or have an issue of your own that you'd like me to address. And again, what I'll do is just read the emails or an email, and then we'll discuss the relevant law. And again, I hope that you find it helpful. This first one is written by an individual who is writing on behalf of her husband, and she says, "Hello, my husband has been working for a retail company for the last 8 years. When my husband applied for the job, he stated on his application that he had a prior felony charge. He talked with the hiring manager at the time about it when he was interviewed, and still he was hired. Now, here 6 years later, we moved to another state, and he was transferred with the same company. Today, they fired him due to his charge, that felony charge she talked about earlier. He has worked for this company for 9 years, for 9 years, as hard as he could, has not had any write-ups, has been promoted twice, and they just fired him. They have offered nothing. He was weeks away from receiving a very nice bonus. All they will give him is the last check, nothing more, nothing less. Is it okay? Can a company just fire you if you were honest 9 years earlier because they chose to? Thanks." Well, we're going to look at this. There are several things that are a part of this email that we need to address before we can really answer the question, give you an answer to the question. First of all, in most states where I practice, particularly in the South, and really, unless you're protected under a contract or under a union collective bargaining agreement, companies can fire you for good reason, or they can base any employment decision on good reason, bad reason, or no reason at all. What they cannot do is base their employment decisions on a discriminatory reason. Now, there's some things going on in this particular case that raise the issue of whether it was considered a good reason, bad reason, or no reason at all. I think here it is a wrong reason. I think it probably would fall under bad reason. But that in and of itself is not enough. We have to look at the rest of what she says here. Even if the company says, it was a bad reason. We fired you. We're sorry. It was a bad reason. You still have to look further. Under the law, they cannot fire you for a pretext, and that is an excuse for discriminatory intent. And we have to look carefully to see whether there was discriminatory intent in this case. What I have not been given is information about how others have been treated. We don't know if perhaps there were other individuals who worked for this company who had a felony charge and were treated similarly, or were treated differently. That would be important. I think it is important to recognize that the company had knowledge. They had knowledge. That's why I say it was a bad reason here, because they had knowledge up front that there was a felony charge. And it says charge and not conviction. And it's interesting, the EEOC has recently changed its position with respect to felony charges and convictions for that matter. Because when you weigh the employment decision on a felony charge and or conviction, it tends to have a disparate impact on a class of individuals, a protected class of individuals, particularly minorities, Hispanics, and African Americans. So you want to look at whether or not that conviction, specifically, whether or not that conviction was related to something that would impact the job. For example, if the individual was convicted of a felony for stealing, and you were applying for a job in retail, or you were applying for a job at a bank, that conviction really relates to what you would be doing in the workplace, as opposed to your having applied for a position as a ditch digger or a construction worker of some sort, and you're not dealing with money. You don't have access to actually having an opportunity to steal supplies. If you're only delivering the work, the service, then it would be a disparate impact on you to be excluded from that position simply because of the felony conviction, but when it really plays no role in what you actually do for a living, or what you would be doing for a living for this company. So having said that, that's a little background information. With respect to this case, though, the individual was only charged. It appears that they were only charged. There's nothing here that suggests that there was a conviction. So, of course, in this country, we are presumed innocent until we are proven guilty. So the fact that they were charged with a crime really should be of no moment to this particular employment situation. I'm told here that the individual worked in a retail company and worked for, I see two different dates here, but it looks like at least 9 years with the company. And having worked 9 years with the company, no write-up, no problem, no write-ups, no problems, and all of a sudden, well, we're terminating you, and we're terminating you because of what you told us originally, and you actually put it on your application. We had knowledge of it, but we thought about it later, and we're going to get rid of you. That raises suspicion. That is highly suspicious that something else is going on here. She says that they moved from one state to another. Did they move because the company asked them to move? That's not indicated here. Or did they move, they needed to move, perhaps a hardship situation, and they were given a position in another company based on their request, the employee's request. To that extent, the company may raise the issue, well, the individual who hired him originally didn't have a problem with that. However, we started a new agreement with him when he moved to the next state. And at that time, that manager, that supervisor, had a different standard for employment or hiring individuals with criminal backgrounds. And because of that, they have a right to say, we don't want to employ him, or we don't want to continue employment with him based on what we know about his background. I don't think that that will hold up, though. And the reason that I feel that way is because she says it was a criminal charge. And again, a charge is not a conviction. So I really would look at how others have been treated and what else is going on. Notwithstanding, you still have to raise, even if it was a bad reason, you still have to raise the issue of discrimination. Was it a discriminatory issue? Was it a discriminatory reason? And there's possibly, and I'll get to this shortly, a breach of contract. We may want to look at that as well. But with respect to the discriminatory reason, could there have been a discriminatory reason? I think so. I think that perhaps you could make the argument that we moved to the next town, irrespective of whether we asked for the move or the company asked us to move. Nothing broke. The chain of employment remained the same. I was working for the same employer. And when I moved to this next employer, Perhaps they terminated me not because of the my criminal charge or the felony charge, but because of my race. If this individual is African American or has a different national origin, is Hispanic or of a, again, another national origin, that may be a reason why. And that may be the discriminatory reason why. I don't know that, but if I were looking at this case, those would be questions that I would ask. I think it's never a good thing for a company to arbitrarily or capriciously make a decision, an employment decision, because it always raises the issue of whether it was a underlying discriminatory motivation. And I think that's what's being raised here. All else failing, you may want to also look at whether or not this was a breach of contract, if particularly if the company asked this employee to move to another state. The employee moved to another state, they get there and the boss says, can't keep you because you have this past 9 years ago you were charged with a felony, irrespective of whether the fact that you were not convicted. And again, based on what I'm reading here, there was no conviction. So now you have what could be argued a breach of contract issue. And then you have to look at the two competing states that were involved. I would recommend that you see an attorney that specializes in civil rights, employment litigation, constitutional law, to ensure that they look at all the possible violations that may have occurred. I hope that you find this this information helpful, and not just specifically to the person who wrote the email, but to others. This is an area of law that I find that's particularly near and dear to my heart, because people have to feed their families, and they should have a right to feed their families without fear of being subjected to discrimination. I respect the fact that companies have to run their companies and be effective and be productive, but I think the two can marry. I think you can be productive in managing and operating a company without being discriminatory. And I hope that, and I think for the most part that most companies are fair and do not discriminate. But when you have one that does and they step out of line, the only way to correct that, for the most part, if you don't raise it with them, and that's a subject for another day, but if you cannot correct it internally, you need to file a charge with the EEOC first, because the law requires, if you're going to file a lawsuit under Title VII of the 1964 Civil Rights Act, which is employment litigation basically, you have to allow EEOC to investigate. They have up to 180 days within which to investigate and give you a finding, after which time you can take your letter of your right to sue into court. Again, I hope you find it helpful. We're going to do this periodically. Hopefully once a month we'll give you issues on employment litigation. If you want more on issues like this, please tune into my radio program, The Valerie Hicks Powe Show. You can hear it on Heaven 610 WAGG, that's the AM station in Birmingham, Alabama, but you can also hear us live streaming on the web at 610wagg.com. And if you would, please, while you're here, there's a box underneath for comments. While you're watching the blog, when you finish, if you would, please give us your comments. We'd love to hear what you have to think about our program and about our blog and any suggestions that you have. I hope you found it helpful, and we'll see you next week.